Yes, Dr. Singhvi.
Yes, I would wish to take your lordships principally to some very interesting underlying juristic principles. Because your lordship have now seen the facts for 2 days, so I'm not going to repeat. Juristic principles which should impel your lordships to decide this matter here and not consider the various options or suggestions of sending it back to the speaker. That's going to be the bulk of my argument. But brothers, I want to start with where we are ending up, because I was here the whole morning and I heard the very important question which fell from the bench, and the Honorable Chief Justice in particular, about the role of the governor. And I'm going to repeat anything, I'm going to try and give a different facet. Well, this is a very unique and a strange case. And I would say from this side, a sorry case, where Lordships has double whammies and triple whammies. Let me explain how. My Lord Manus put the question of the governor's role. And in one sentence, the question is that if your lordships if the governor found that there is something to be decided by way of unstable majorities, even if you exclude 39, why can't he go and have a trust vote, etc., or a decision on the true majorities in the confidence of the House? Well, it's the first thing when you start on that query has been perhaps not given sufficient weight. And the first thing is that your lordship's fundamental rock-solid principle of interpretation of constitution and statutes is that if intentionally a constituent assembly in its amending power of the constitution deletes something, your lordship gives full effect and scope to the intendment behind that deletion. That is well as axiomatic. It is obvious purely whether it's contract or a statute, much less a constitutional amendment, where your lordship's intention is to give effect to that intention.
So para 3 has been deleted.
Now, para 3 deletion is not a small thing. There are debates, there is a SOR, the Constituent Assembly, the Constituent Parliament in its constituent capacity said, look, we must delete it. Why this case is bizarre is that there are three, at least two, circumventions of that deletion directly by high constitutional authorities. Circumvention 1 is clearly this way or that way, whether the governor can do it or not do it, the lordship will decide separately. But clearly and specifically, the governor is acting on a presumption of a split. In whatever way he is acting. Now, as a governor, most of all is supposed to know the constitution. All of us are supposed to know the constitution, and ignorance of the law is no excuse, much less ignorance of the constitution. There is no system, and I'm not talking of your lordship's narrow question of trust vote, non-trust vote. There is no basis on which your lordships can reconcile and harmonize the factual invitation and oath giving on the one hand with the legal deletion of para 3. That's my proposition. The two are irreconcilable. And that is a very major constitutional sin underlying this whole supposition and context. The second makes this even more bizarre. There is no counterpart to curiouser and curiouser. It can't be bizarre and bizarre. Well, there is a direct finding in not one but many paras of the EC order that this is a split. I'm not asking Lordship Justice Shah is right. We are not on the appeal on that. That's not the point I'm arguing. I'm on the context, fellas. People are here going around merely on the assumption of a split, then the Lordship might as well wind up the 10th schedule, the constitutional amendment, the deletion. What's the point of it? I'll give the paras, there's more than 4 paras or 3 paras in the EC. Just give the paras. Yes. Now, Millets, therefore, your lordships and those cases don't have to be given to your lordships of elementary forms of interpretation that if I delete something, your lordship gives effect to the deletion. I'll supply them, Millets, not necessary to do it. The second answer, or the second Millets response in the larger context of that query. So this is the first response. The second is, your lordships decides cases, not that your lordship decides the narrowest of narrow issue, lordship decides the whole context. But your lordship doesn't decide beyond the context of a case. Your lordship is very careful, otherwise all the things of biter and all that come in. And your lordship doesn't have time to spend on hypothetical questions. But let us see the context. The context of this case can be divided into broadly three or four categories. And that context makes it clear that your lordships need not be bothered about the governor coming into the picture at all. The first phase of this context is the expedient of giving a disabling notice. I call it a disabling notice before I intend to defect. Now that will be awaiting your lordship's decision on nabab. So phase 1 or part 1 of this context is disabling notice. Your lordship must decide in nabab. That's the whole argument we made for 2 days. But clearly the context is that step 1. And if that is wrong, then a lot of things fall down. And that is wrong in case a lordship doesn't agree with the literal text of nabab. The second part is that we are also forgetting repeatedly the object of the 10th schedule. Well, as more than any other jurisprudence in this part, subject of constitutional law, are cases again and again talking of 2 things. The evil prior to 84, the object of plugging that evil, the mischief rule, and what your lordship is doing by the 10th schedule. The third is that if your lordships accepts that the basic object of the 10th schedule is a constitutional sin being precluded or stopped or reduced, then 2-1 A or B as the case may be has to be decided first. It's logically prior to everything. Not only is it prior in terms of serial number, but conceptually it has to be logically prior to any decision of any kind in any case. I'm talking of concept, I'm not talking of a delay by an individual speaker. Whether the Kerala speaker will decide tomorrow, Nagaland speaker may take 6 months, a Manipur speaker will take, that's not the point. Conceptually, the logically prior decision has to be para 2, not a governor's intervention collaterally in any which way. That's the structure of the 10th schedule. And that scheme and structure must be endorsed and strengthened by our lordships. Inter alia by not accepting any collateral incursion horizontally sideways by a governor, while that 2-1 is still pending. The fourth. Other aspect of this, which has to be given a lot of weight is, apart from what we just talked about the trust vote, people tend to forget that in almost every assembly, there is a very interesting rule. You cannot bring repetitive no confidence motions also.
6 months.
Your lordship knows 6 months. So I bring a no confidence against you, I lose it, I can't come after next week and say I have no confidence against you. So, the next facet of this is the processes within the parliament and assembly have to be allowed to work themselves out first before external intervention.